Hello everyone, and welcome to this video, which is on one of the special duty situations in tort, namely economic loss. I have to start by saying economic loss is a popular exam question, particularly at A2, A level, and particularly with AQA. And it is quite simple. It's not a difficult concept, yet it is one that students tend to shy away from. So let's take a quick look and see if we can get some easy exam marks under our belt. And I want to start just by saying that all of these special duty situations are extensions of the duty of care part of our equation. We will, of course, still have to prove breach of that duty, and we will still have to prove that there was damage, causation and remoteness. But most of what we see on this video and the other special duty situations like vicarious liability and occupier's liability will be about the establishment of a duty of care. Then in the exam, once we've done that, we will quickly go on to talk about breach and damage if it's relevant. So let's start by looking at what we mean by economic loss, and it's relatively straightforward. Economic loss is where somebody incurs financial losses which are not attributable to the physical harm caused to the claimant's, obviously not property, but to the claimant's property. So when my car is damaged in a car traffic accident, there are two types of loss. One is the physical damage to the car itself. That is not economic. But the cost for me to put it right is an economic cost. So an economic loss is one that is attributable to physical harm, or which is not attributable to the physical harm caused to the claimant's property. And it will include things like a loss of profits, a loss of trade, and a loss of investment revenue. Economic loss is about damage to one's wallet. And there are two types of economic loss. One is consequential and one is pure. And the rule is very, very straightforward. You can claim for consequential economic loss almost always, and you can never claim for pure economic loss. Now, I know what you're going to say, and you'll be quite right. There is an exception to that, and we'll come to that later. But firstly, get the general rule under your belt. You can always claim for consequential economic loss. You cannot claim for pure economic loss. Consequential economic loss is where the claimant suffers a money loss because he has suffered an item of physical loss. So let's go back to my car. It costs me money to put my car right. That is a money loss. And that occurs because I've suffered a physical loss, i.e. the damage to the car. The economic loss is consequential on the physical loss. That's why it's called consequential economic loss. Another example might be a worker who loses wages if they're injured at work. They will be able to claim for those wages back. I will be able to claim for the money it's cost me to put my car right. So a physical loss or injury leads directly to a monetary loss. Pure economic loss, on the other hand, is stand-alone economic loss. So let's think of a good example. I am driving on the M25 en route to my holiday. Somewhere 10 miles on the M25 north of me, some idiot has a car crash, probably because he's on his mobile phone or eating sweets or something ridiculous. And he has a car crash in front of me. And I am now stuck in that traffic accident. I'm not a part of it. My car's not damaged. There's absolutely nothing wrong with me. The accident is some miles ahead of me. But I'm now stuck. And because I'm stuck on the motorway, I miss my flight. Which means that I can't go on my holiday. I have suffered no physical loss. Yet I am out of pocket. Purely being out of pocket is not sufficient to be able to claim. And there are some reasons for that, and we'll look at the reasons for that in a moment. But that would be pure economic loss. My car's not damaged, I'm not damaged, there's no damage physically to any of my property. And therefore I cannot make a claim for that loss. And I've put a couple of key cases up here which help us to understand the difference between these ideas. And the first is Spartan Steel and Alloys Limited versus Martin and Company Contractors Limited of 1972. And the issue here is that the defendant were an electrical contractor. The plaintiffs are a steel maker. And if you aren't aware with how metal, particularly steel, is made, metal ore is heated to ridiculously high temperatures until it melts and the impurities are skimmed off, and then it's poured out and made into metal. Well, whilst this was happening, whilst Spartan Steel and Alloys Limited were actually melting metal ore at ridiculously high temperatures, the defendants negligently cut off the electricity supply to the steelworks. That involved 3 losses. The first loss was the loss of the steel. So all of the steel that went, stopped being in a molten state, went hard in the furnaces and had to be cleared out. That steel is then ruined. The second is the loss of profit from that steel. The third was the loss of profit from 3 extra melts. Now, those extra melts had not taken place yet. They were the work that was going to happen in the afternoon. The court said that Spartan Steel could claim for the loss of the steel. The steel itself was damaged, couldn't be used again, had to be thrown away. It also said that it could claim for the loss of profit lost as a consequence of that steel being broken. So these two are consequential economic loss. But what it could not claim for was the loss of profit from the 3 extra melts that had not taken place, because that steel ore, that metal ore, had not been damaged. It had not even been made yet. The impact was purely profit, and because it was purely profit that was lost, it was a pure economic loss and no claim could be made. Okay, so what we need to do now is we need to look at the key rules. Where do we get this idea? Where does this notion about pure economic loss start? And the starting point, the decision, can be tracked back to the decision in Cattle versus Stockton Waterworks. It's got nothing to do with cows, even though I've got cows there. I'll talk about that in a moment. But Cattle versus Stockton Waterworks is where we find the first notion of the rule about pure economic loss. And the defendants negligently burst a water main, which added to the plaintiff's costs in completing a contract with a third party. They were building a tunnel. So the loss of the water, the bursting of the water main, meant that the cost of completing the contract was increased. And the courts decided that this was pure economic loss, not linked with any physical damage to the plaintiff or his property, and therefore it was unrecoverable. And we've seen the same thing again a much later date now, so we're now looking at nearly 100 years later, in a case known as Weller versus Foot and Mouth Disease Research Institute. And the plaintiffs sued for the loss of 6 days' business when the markets were closed because of an escape of virus from the defendant's premises. And the judge said again that the defendants had no case to answer, that possible future loss of profits was a pure economic loss and therefore could not be claimed for. Now, you might say that seems relatively unfair, but there are some really important reasons for that. It's a bit like psychiatric damage. There are some really important reasons as to why the rules are so strict. And the first is the old floodgate argument. Go back to me on the motorway. Let's say there are 10,000 cars stopped on that motorway, and there must be accidents around the country every single day. If we were to allow pure economic loss claims, everybody would be claiming and the floodgates of claims would open. A single incident can lead to an unknown number of claims, and they would be huge. It's also difficult in calculating future losses. So how much do you know how much profit you're going to make? How much do you know how much money you're going to make in the next 2 or 3 weeks because of the injury? And finally, you might be suing in negligence to avoid a contract clause. So if I can't complete my clause on my contract, in normal business sense, I might be suing to get out of my contract. So for those reasons alone, especially the floodgate one, we tend not to allow claims for pure economic loss. But as with everything, there is an exception, and I've put or two because we'll come down to other exceptions down here, look in a moment. But there is a key exception, and that exception is the one of negligent misstatement. The defendant is liable if they make a statement to someone to whom they owe a duty of care. So they've got to make a statement, and there's got to be a duty of care as a result of that statement. And that's due to the defendant's negligence, the statement becomes inaccurate. It's one N, isn't it? Inaccurate. And that causes the claimant a reasonably foreseeable pure economic loss. So a reasonably foreseeable pure economic loss. And that could include written or verbal, and it could be in a number of forms. It could be, so I've got a map here, look, it could be a report, it could be a map, this is an old treasure map. X marks the spots, is where the treasure is. Or it could be accounts, any of those sorts of things. But if somebody makes a statement to whom they have a duty of care, and that statement is inaccurate, and it's reasonably foreseeable that economic loss will occur, then you may have an exception through the law of negligent misstatement. And the key case that identifies this is a case called Hedley, Byrne versus Heller in 1964. And in Hedley, Byrne versus Heller, the plaintiffs were advertising agents who booked TV advertising time on behalf of an entertainment company. They asked their bankers to obtain a reference from the entertainment company's bankers. And the latter, the bankers, replied favourably. The bankers said, yes, this company is solvent, it's got lots of money, don't worry. And the advertising agents used their own money to secure the booking with the TV firm. Well, the entertainment company that the bank had said was perfectly solvent and they were brilliant, good for the money, went into liquidation. And the plaintiffs lost their money. They'd lost the money that they'd paid to the TV company. And they sued the original bankers who said everything's fine. And the House of Lords said that the bankers owed the plaintiffs a duty of care. Now, in Hedley Byrne, they escaped liability because they'd put a disclaimer in the statement denying legal responsibility for its accuracy. So they got away with it because of a disclaimer. But the rules that were set out in Hedley Byrne made it very clear that negligent misstatement can exist. Now, this does raise the risk of unknown and unpredictable liability. Take, for instance, a newspaper column. If I write an investment column in a newspaper and I put in there that everybody should buy this company's shares and I get it wrong, that sort of, Hedley Byrne sort of suggests that I might be liable for negligent misstatement. And all of the reasons that we said above about the floodgates and what other future losses might come into play. So it's not a rule without controversy. And because of that controversy, the judges in Hedley Byrne made some very clear rules. The first is that the whole thing is predicated around a special relationship. If we've got any international affairs students or politics students or history students, you'll know that I've just used this as a to denote the special relationship between us and the USA. But the judges in Hedley Byrne say that there has to be a special relationship in order to give rise to a duty of care. And in order to do that, in order to identify this special relationship, there are 5 key elements. The first element is that the defendant must possess a skill or expertise. The second element is that the defendant voluntarily assumes responsibility for their statement. The third is that the statement must be made to a known user. The fourth is that statement must be made for a known purpose. And lastly, there must be reasonable reliance on the statement that's been made. So when we are answering questions on economic loss, we would start by saying 2 types of loss, consequential and pure. Never normally be able to claim for pure unless there's a negligent misstatement. Negligent misstatements are set up in Hedley Byrne. Hedley Byrne says that there has to be a reliance on a special relationship, and you prove that special relationship by these 5 key elements. And then in your answer you would go on to look at each of these key elements. So let's do exactly that. Let's take a look at these key elements. So we'll start by looking at the defendant should possess a skill or expertise. And this is normally about, oh look at this, my spelling's awful today. This is normally about professional advisors. So accountants, sets of accounts, surveyors. So let's write some of these down. So you were looking at accountants, surveyors. You might be looking at solicitors and legal advice. But it can be extended to a non-professional. All right. And the first case we're going to look at is Lennon versus the Metropolitan Police Commissioner of 2004. And in that case, the claimant was a policeman, I think, transferring between forces. And the police officer asks a clerical officer in the defendant's personnel department for advice on his eligibility for a housing allowance. Liability was established because the clerk gave wrong information, with the result that the claimant lost financial payments to which he would otherwise have been entitled. So the skill in this case was the skill of the clerk. But it can also be transferred to a social setting. And this is the bit that's scary. So think about this whenever you're given advice, particularly if it's legal advice, because you've done a little bit of, you've done your law A level. In Chowdhury versus Prabhakar, 1988, a friend with some knowledge of cars agreed to advise a newly qualified driver on a second-hand purchase. The car he recommended was later found to be wholly unsuitable. I think it had been in an accident actually, and he'd not noticed that. And he had not described that accident and that unsuitability. The Court of Appeal held by a majority that he was in breach of his duty of care, that a duty of care was established and that he was in breach of it. So a car in a social setting. Two of the judges said that although no duty of care is ordinarily imposed on a person given advice within an ordinary family or social relationship, there was a duty in this case. The standard required was an objective one, namely, such skill and care as persons ordinarily exercise in their own affairs, or where the defendant has held himself out as having a particular skill, and such skill and care as would normally be shown by a person having that skill. So if you are claiming that you know cars, and you are claiming to have a skill about knowing cars, and you advise somebody, then your duty of care could be established. So think about us. We are all budding lawyers. We understand the law far more than our peers around us. If we were to give legal advice and somebody relied upon it and then subsequently lost money, Chowdhury versus Prabhakar says that we might fulfil the first part of the rules in Hedley Byrne. The second is this notion of an assumption of responsibility. And in that, the defendant must state to the claimant that he is prepared for the claimant. So D states to C that he is prepared for C to rely on advice. Now, in a professional situation, that's normally through a contract or normally through a fee payment. And this is because the defendant does not have to give advice. He can decline if he's unsure. Or he can add a disclaimer to his liability, as in Hedley Byrne in that instance. And in the case of Hedley Byrne, of course, a defendant doesn't have to give the advice. He declined it. So in Hedley Byrne, he got away. The defendants got away in Hedley Byrne because they put a disclaimer in the contract. The third element is this notion of a known user. And this will lead to one of my favourite cases, I have to say. And you should only be liable if the defendant knows or should know, when making a statement, the identity of a person or a class of people relying on the statement. So, let's look at Caparo versus Dickman. You'll remember Caparo versus Dickman sets up the sort of new modern test for establishing a duty of care. But Caparo versus Dickman in itself is a case about economic loss. The plaintiffs bought shares in a public limited company with a view to taking it over. And they bought more after seeing the auditor's report for that company. The shares then fell in value, and the plaintiff sued the auditors for their negligence in preparing the report. Now, essentially, the auditors were preparing the report that they made, not for future purchasers of shares. They were producing the report, effectively, for the company in which shares were being bought, not for somebody buying those shares. So the known user was the company, not the share purchaser. So in Caparo versus Dickman, you get an idea that the House of Lords says that the auditors did not owe a duty of care to the investors thinking of buying shares. Now, let's take that one stage further and look at Goodwill versus the British Pregnancy Advisory Board. And in Goodwill, a doctor employed by the defendant carried out a vasectomy on a man. And they advised him that it was no longer necessary for him to take contraceptive precautions. Sometimes after that vasectomy, a woman became pregnant following intercourse with the man and sued the defendant for giving negligent advice. The Court of Appeal allowed the defendant, the British Pregnancy Advisory Service, allowed their appeal and struck out the plaintiff's claims. And the reason for that is that the doctor undoubtedly had a duty of care to the man and perhaps to the man's wife at the time of the operation. But she would have had to have been involved in the discussions, and she would have had to have been there when they said those things. But they were not liable, they did not have a duty of care to the undetermined class of women that this man might have intercourse with later down the line. The known user was the man or his wife/partner at the time. They're not liable for people that he sleeps with later because they cannot possibly know who those people might be. So I hope that makes sort of sense. You have to know. You should only be liable if the defendant knows or should know when making the statement the identity of a person or class relying on that statement. Let's move down and look at known purpose. Known purpose again, I mean this is quite technical stuff really, but the 5 key elements are relatively straightforward. The defendant should only be liable if he knows or should know when making a statement what the statement will be used for. So previously, we needed to know who the statement was going to be used by. We now must know what the statement, so this is who and this is what. So what is the statement going to be used for? We've already looked at Caparo. I mean, that's the same thing, isn't it? They think that they are preparing the accounts were drawn up for the purposes of complying with company law and also of allowing the shareholders of a group of people to exercise control over their company. The accounts were not drawn up for the purpose of a takeover through share purchase. So the purpose was for the company to comply with company law, not for people who they didn't know to try to take over the company. A second example of that is Riemann versus the Department of Transport. And in that case, the claimant had bought a boat on the strength of a seaworthiness certificate issued by one of the defendant's inspectors. The certificate had been negligently prepared and the boat was unsafe and therefore of little value, to be honest. And particularly when that was compared with what the claimant had paid for it. However, the claim for negligent misstatement failed on the grounds that the certificate had been produced for the purpose of complying with regulations designed to promote safety at sea, not for the purpose of putting a commercial value on the boat. And lastly, the third of our cases in this area is the case of the Law Society versus KPMG Pete Marwick. KPMG are a famous firm of London accountants. And that famous firm of London accountants had prepared the annual accounts for a firm of solicitors. The accounts did not pick up the fact that large amounts of the client's money were being stolen. When the true picture emerged, the claimant's compensation fund had to pay out to the victims of fraud, and the claimant sued to recover the loss from the defendant. The claim succeeded because although the accounts were prepared for the solicitor, the defendant knew first that they would be passed to the claimant, as that was part of the regulation governing the solicitor's profession. And secondly, that the purpose of the accounts being passed to the claimant was to allow it to make a decision as to whether to intervene in a particular solicitor's practice to stop fraud and minimise claim against the compensation fund. So in the Law Society versus KPMG Pete Marwick, liability for negligent misstatement can exist when the defendant should know that his statement will be passed to a third party and what that third party will use it for. So you've got two cases in which there is no negligent misstatement and one case in which there is. All right, so those two, no negligent misstatement and a case in which there is. The fifth of our key elements for economic loss is this notion of reasonable reliance. And reasonable reliance, the claimant must show that he did in fact rely on the misstatement. And of course that it was reasonable in the circumstances for him to do so. So let's have a think. A common example is the contract between a business appointment and a drinks party. It's reasonable to rely on advice given by a professional person at a formal consultation. It's not reasonable to take advice given by somebody late in the evening after several drinks at a drinks party. So, I mean, be careful and remember, go back to Chowdhury and the idea of the car. So there is a fine line to be tread here, but generally the idea is if you're going to go to somebody's office, pay them money, sit and have a proper formal consultation, that in itself is reasonable reliance. If you ask somebody who might be an expert in something at 11 o'clock at night after you've had a skinful of red wine, that's unlikely to give you any form of reasonable reliance. And a good example here is Smith versus Bush. And that's a case in which the claimant is a purchaser of a house. And he had approached a lender for a mortgage. And what happens when you buy a house is that you have two, generally you go to a surveyor to see that that the house is worth what you're paying. But the people who lend you the money will also go to a surveyor to make sure that the money they're lending is the right value and property for that for the property. So the two surveyors, one were working on the contract for a building society and the other was employed by a local authority, and they negligently overvalued. So they overvalued a house. So they said it was worth more than it actually was. The bank lends money on that overvaluation. The prospective purchasers, who had paid for the surveys to be done but had no contractual relationship with the surveyors, bought the properties on the strength of these reports and subsequently found that the houses were worth less than they had paid. They sued the surveyors for negligent misstatement, and the surveyors relied on exclusion notices in their reports. The House of Lords said that the surveyors were liable. They knew the purchasers were paying for the valuation and would only sign a contract if the valuation was satisfactory, and they might suffer injury or damage if the valuer did not exercise reasonable skill and care in these circumstances. So, the exclusion notices, actually, just to continue that on, were void under the Unfair Contract Terms Act, which is why they couldn't diminish their duty through their contractual obligation. So, our 5 key elements. Let's just whiz back here quickly. The defendant must possess a skill or expertise. The defendant voluntarily assumes responsibility for their statements. There must be a known user. There must be a known purpose. And there must be reasonable reliance. Now, there are 3 other simple explanations. Simple exceptions. The first is where there is a beneficiary of a will. The claimant is a beneficiary of a will. Estates cannot sue because they lose nothing. The intended beneficiary cannot sue as he is not the client of the solicitor. So therefore, an exception has to be made. And a good example of this is White versus Jones. And in White versus Jones, a testator, the testator's solicitors negligently delayed preparing his will, and as a result, the dead man's daughters did not receive the money that the dead man intended them to have. Let me explain that. I'll probably best if I do that by drawing, actually. So you've got dead man, all right? Sorry, but it's the easiest way to explain it. You've got a dead man. He goes to his solicitors to prepare his will, to change his will. He dies. His daughters, who should now get more money because of the new will, don't get money because the solicitors were late and didn't do it in time. So they did not do work. So the daughters lose out. And as we've said earlier on, that's obviously an automatic loss. In this instance, the court says very, very clearly that this type of liability is recognised. Because of the solicitor's poor work, the claimants lost their gifts, because the effect was given to the existing will, not the new one that the dead man had written. So they were allowed to recover their loss. The second exception is where services are provided. And the case here is Henderson versus Merit Syndicates Limited. And this revolves around something known as the Lloyd's List. If a special relationship exists, the claimant can sue for pure economic loss caused by the negligent performance of a professional service. And these were a group of cases. This is about the Lloyd's List. I'm not going to explain the Lloyd's List because it's far too complex and steeped in maritime history. But in a group of cases heard together, a number of Lloyd's names sought to sue their underwriting agents for the negligent management of syndicate business, and that had led to losses. In interlocutory proceedings in the House of Lords, it was held that the agents owed a duty of care to the names, whether or not there was a direct contractual relationship. An assumption of responsibility by a person rendering professional or quasi-professional services, coupled with a concomitant reliance by the person for whom the services were rendered, could not give rise to a tortious liability, no matter whether there is a contractual relationship or not. So, What does that effectively say? That says that the House of Lords decided that if the services in question were performed under a contract between two parties, then liability and negligence could exist side by side with the liability for breach of contract, unless the contract specifically excluded liability and negligence. The reason why a claimant in these circumstances might want to sue in negligence rather than for breach of contract is that the time limits for bringing an action in negligence are more generous. I hope that makes sense. And the difficulty with Henderson versus Merritt is it's incredibly technical because it involves things like underwriters and Lloyd's names. So it might just be worth you taking a wee bit of time just to research that case online, spend a bit of time understanding the complexity of it. And finally, which is really the scary one for all of us, those of us that might at some stage have to write job references, is that you can also be liable, an employer can be liable for pure economic loss caused by a negligently prepared statement in a job reference. In this case, the claimant suffers an economic loss because a third party relies on the defendant's job reference. The case here is Spring versus Guardian Assurance, and in that case, the plaintiff was a former employee of the defendants. They asked them to supply a reference to a prospective future employer. The reference supplied contained inaccuracies, which seriously prejudices the plaintiff's chances of obtaining the sort of employment that he sought. And the House of Lords held that an employer who provides a reference in respect of an employee, past or present, owes a duty of care to the employee in respect of its preparation, and they will be liable for any economic loss suffered by the employee as a result of the negligence. So, relatively straightforward then. We'll quickly cut through it again. Economic loss, always claimed for consequential, never claimed for pure economic loss, unless there's a negligent misstatement, and a negligent misstatement as detailed in Hedley Byrne is the result of a special relationship which is defined by the possession of a skill or expertise, a voluntary assumption of reliability, a known user, a known purpose, and reasonable reliance. There are three other exceptions, and those are beneficiaries of a will, where services have been provided, and in job references. I hope that has gone some way to work through and help you to understand economic loss.